Okay, if everyone's ready, I'll begin. Ladies and gentlemen, as I'm sure some of you may remember, when studying a postgraduate course in conference interpreting, often we very fortunately have the option to visit the big institutions that hire interpreters, such as, for example, the EU or the UN. During the course of my MA programme, we referred to this visit as a study visit, and we visited the Council, the Parliament and the Commission in Brussels. When we were there, we interpreted in a dummy booth and attended workshops alongside students from Stockholm University. At the time, we flew from Dublin to Brussels. When we arrived in Brussels, the Commission were very generous and provided us with accommodation for the 3 days of the study visit. But we also made a bit of a holiday out of it. We stayed a further 3 days and spent each and every one of those days fantasizing about our future lives as staff interpreters at the EU. That fantasy still hasn't come true yet, but we'll not speak about that. The experience of the study visit was definitely a key element of the MA programme, for me anyway. It kind of helped me get through difficult Christmas exams or moments of harsh critiques or moments of doubt. It was just a very nice experience overall. However, recently I began to wonder, how would a study visit like this work if I had been completing the MA programme in 2021 and not 2019? The study visit in 2021 couldn't involve an international flight, really. It also couldn't involve 3 trainee interpreters piled into a dummy booth together, interpreting practically on top of one another, much less a boozy bar crawl in Brussels. So how would this trip take place? Well, fortunately, I received my answer to this question recently when I was invited to join in my alma mater's study visit to the Court of Justice of the European Union, which I will refer to as the CJEU throughout the speech. Albeit this study visit was, of course, in virtual form. I also found out that students of the MA programme this year are doing virtual visits to the CJEU, but also to the Commission, the Parliament and the UN. This wasn't an option when back in my day in 2019. So virtual study visits do have their benefits as well. So getting back to the Court of Justice of the European Union, I, of course, very gladly accepted the invitation to this virtual study visit, and I'm very happy that I did, as it was extremely informative, and it was presented by a staff interpreter at the court from Ireland, who was both very knowledgeable and absolutely hilarious in equal measure. He talked to us about many things, including the different languages used at the court, his experience of starting out as a staff interpreter at the Court of Justice, and the particular difficulties that are involved with interpreting in this particular institution. He also talked to us about the various training sessions that him and his colleagues go through. However, one of the most interesting things that he talked to us about was the cases that pass through the Court of Justice. He tried to stress to us how many people think that the cases before the CJEU are just abstract cases about some strange, obscure provision of EU law. But what he tried to stress was that this is not the case, that the cases brought before the court are very applicable to real life and very current, and that some of them are even very funny. One of the cases he mentioned was where Lindt, the Swiss chocolate maker that I'm sure we're all familiar with, tried to trademark their gold bunnies that are sold at Easter. It's very unsurprising that they tried to trademark this product, given that they sell around 90 million of these bunnies per year. I imagine a large portion of this is at Easter time. Another interesting case that was brought before the CJEU was one in which the court had to rule on where VAT, or value added tax, was to be charged for pornography services created outside the EU, but consumed within the EU, for lack of a better verb. But all of the cases mentioned in this study visit were very interesting, but of all of them, the one that struck me the most was the case of baby S, as the press is referring to this child. I'll explain. For those of you who don't already know, baby S was born in December 2019 in a hospital near Barcelona, where her mothers live. And after she was born, as is normal, she was issued a birth certificate in Spain. This birth certificate listed both her mother's names, one of which is Bulgarian and the other of which is Gibraltarian. So baby S's mother applied for a Bulgarian birth certificate for her daughter. This was because you need a Bulgarian birth certificate to apply for, rather, Bulgarian citizenship. But baby S's mother was unsuccessful. Why is this? Well, this is because the Bulgarian authorities apparently told baby S's mother that a baby could not have two mothers. This is very shocking, but it does line up with the fact that Bulgaria's constitution defines marriage as the union of a man and a woman. As far as I understand the situation, the Bulgarian birth certificate forms require the name of the mother and the father. There's a part that says mother's name and a part that says father's name. So baby S having two mothers is powerless under administrative law. Well, baby S's family is powerless under administrative law. This, of course, strikes me as blatant discrimination on the basis of sexual orientation. And I'm pretty sure this kind of discrimination flies in the face of Article 21 of the EU Charter of Fundamental Rights. It's quite clear. In any case, the family cannot get Bulgarian citizenship at the moment for baby S. So what are their options? Well, they could maybe acquire Spanish citizenship for baby S. Baby S was born in Spain. Why not? This would also seem like a good idea because Spanish nationality would grant the same rights as Bulgarian nationality in terms of freedom of movement and working in the European Union in the future. I thought this was a good solution, and that baby S would of course be granted Spanish citizenship being born in Spain, but alas, I was very wrong. For example, if a baby was born in my member state, Ireland, they would automatically have the right to Irish citizenship. It wouldn't matter what nationality the baby's parents were. However, in Spain, as far as I know, and I'm sure you can all tell me correctly, you all know a lot better than me, in Spain there is a series of other conditions that must be fulfilled for a child that is born to non-Spanish parents. So here comes the complication for baby S. No Bulgarian citizenship due to blatant discrimination. No Spanish citizenship because that's not how Spanish citizenship law works. So what other options do the family have? One of baby S's mothers is Gibraltarian. So I know what you're thinking. Maybe baby S can get a British passport, as Gibraltar is, I'm not sure of the exact terminology, but an overseas territory of the United Kingdom. Of course, it may not be ideal for the family in terms of living or working in Barcelona in the future. It also may not be ideal in terms of freedom of movement if baby S wants to visit her grandparents in Bulgaria, for example, in the future. Who knows? But the bottom line here is that baby S needs a passport. And if she can't get a Spanish one and she can't get a Bulgarian one at the moment, then surely she needs a British one. And of course, you would think she should have the right to a British one. One of her mothers is British. Wrong again. Unfortunately, baby S's mother cannot pass on her British citizenship, as she acquired it by descent and not by being born in the UK. So if baby S's mother had been born in the UK, this would not be a problem. However, because that's not how she acquired her citizenship, it is a problem. So what do we do with baby S? Due to Bulgarian, Spanish, and British law, baby S could be left stateless. This is a huge problem. Statelessness, prolonged statelessness, may impede her ability to access healthcare in the future, or education, or work. And this absolutely cannot be allowed to happen. So this is where the CJEU comes in. Baby S's Bulgarian mother will urge the Court of Justice of the European Union to request that Bulgaria provide baby S with a birth certificate and subsequently with nationality. And I don't know about you, but I think this is totally reasonable. While the restrictions of all three countries are placing baby S in a precarious position, only one of these countries is doing so out of blatant homophobia. So it's a matter of opinion, but I believe that it is Bulgaria who should budge in the end. And we will just have to wait for the result of the CJEU's ruling. Thank you.